Welcome back. It is 1 o'clock Eastern, and we have a lot to get to this afternoon. Just want to, one reminder, and per the protocols, I want to make sure just to mention to preserve time, that the negotiator should not repeat a previously made point when it's their turn to speak. And also a point is that Dr. Laura Racer-King is in for accrediting agency. Greg, where would you like to pick up as we start off the afternoon?
So I believe we had finished our discussions on 26, so I'd like to move to 32.
Okay.
If we can do that, and Renee will be bringing that up. Okay,
thank you,
Renee. So here we are in 32. We have clarified in the section that the requirements apply to all states in which the institution enrolls. And so we'll look at that in this is in 32. In each state in which the institution is located, or in which the student in which students enrolled by the institution are located, the institution must ensure that each program is programmatically accredited if such accreditation is required by the state or a federal agency and satisfies the applicable educational prerequisites for professional licensure or certification requirements in the state, so that a student who completes the program and seeks employment in that state qualifies to take any licensure or certification exam needed for the student to practice or find employment in an occupation that the program prepares students to enter. So that was the only one we had left in this section. So I'll open the floor to comment or discussion.
Renee, if you could stop sharing, that'd be great. Thank you. Let's see here. Okay, I see Johnson, you're up.
Yeah, hi. So can you hear me okay? I've been having internet connections today.
You sound good.
Okay, great, thanks. So I want to talk not so much about this provision, but about transcript withholding, which would go into this section. We have discussed this for a while throughout the rulemaking, and I want to make a pitch as to why we should say a school would not, it needs to basically sign a contract saying it's not going to withhold transcripts in order as a debt collection tool or as a retention tool for that matter. So I don't want to go over the same old stuff, but I have some new stuff I want to say. I've been looking at data because data really is important when creating policy. So as I mentioned before, if you look at SUNY's data on cases that go to the Attorney General and where there is not a resolution and hence transcripts are being withheld, you see when you look at all the students who go to SUNY, 99.25% of the students are paying their debts. And so I had a FOIA from Brooklyn College, which basically says the same thing. It says, look, at the end of, when the semester is beginning, the kids who are coming back, 3.75% of them have a debt. But after we use the traditional collection tools, which is essentially we're not going to let you re-register, we reduce that down to about 1%. So the 1% who don't go back to school and end up having their cases have transcript withholding are largely people who can't afford it. People want to pay their schools to go back to school because they want their degree, and they want, as you've seen here on a lot of the Zoomcasts, people have their diplomas on their walls. People want to finish up at schools, and they're going to finish that balance. So the other thing is, so how effective is transcript withholding as a collection tool? Because I'm saying, first of all, it doesn't affect that many people, but to the extent it does, how useful is it? So there's some data out of Ohio that says about 7% of people having their transcripts withheld will actually repay the debt, and the SUNY says about the same. So said another word, like 93% of people who have their transcripts being withheld are not going to pay off the debt. So it's just not helping. It's not working. And so the last thing I want to talk about is just the size of this problem. So there's a data point out there by a bunch of policy wonks. It says 6.6 million people are having their transcripts withheld. If you just look at the data, I've looked at that, it's about 1% of the population that's going to school. There's about 20 million students every year going to undergraduate institutions. So that's about 200,000 students a year. And we've been spending here, we'll be spending 3 weeks on rules designed to protect students that involve about 1 million students, maybe 1.25 million.
30 seconds, Johnson.
And so I think this is really an important issue for the secretary to address. This is something that affects 200,000 students a year, and it's within the purview of the regulations of what we're discussing now. And it's also the arbitration provision was put in exactly for this reason in the same section, and then rescinded, and then it's up for nomination again. So I just think it's before this group. Thank you.
Thanks, Johnson.
Thank you, Johnson. Carolyn, I see you next.
I wanted to also support the suggestion to include a provision in PPAs that prohibits transcript withholding as debt collection. And I think Johnson made a really persuasive argument about how important that is as a goal here. And it is directly related to the investment of Title IV funding, in that the transcript withholding for such people who, as a debt collection mechanism, does also affect the people's ability to continue their education, potentially, re-enroll, and so the investment of Title IV funding and as well as their own funding to that point is essentially stranded or wasted through this practice that prevents people from continuing their education.
Thank you, Carolyn. Let's see. I see on my list I have Ernest. That's what I have next.
Thank you, Kevin. Yeah, it feels important to really verbally support what my colleagues Johnson and Carolyn have shared on transcript withholding and the importance of taking it up as part of this rulemaking. Does, I think, fit with the themes of this rulemaking and the issue papers at hand. I think it fits in this section as well, and it fits as a thing that I would hope that the department would consider important to kind of think through its agreements with institutions and its practice. I can share to the chat the research that Young Invincibles did with Student Borrower Protection Center, which I believe I brought up last session, about the kind of racial equity impacts of transcript withholding as we found them. And as part of the CUNY system, I would re-up what my colleague Johnson said about the effectiveness of this collection tactic. And I would just summarize to by kind of sharing an additional piece and an anecdote. When I stopped out of school after my mom got sick, and I, quite frankly, I think from there was very lucky. I got a job at the Department of Education that turned into a career. I think I was much more lucky than a lot of my peers who have to make those kind of decisions. And it still took me years to pay back my institutional debt and receive my transcript so that I could transfer because of all the other responsibilities that I had. I think this is a common thing for a lot of students who want to even maybe transfer out to institutions at lower cost, but can't because their transcripts were withheld. And I would just urge the committee to consider that. And I'll share the stuff I was talking about.
Thanks, Ernest. Kelly, you're up.
Okay, going back to certification, which is what we were talking about in number 32. Since our last meeting, there has been, we've received significant opposition to Romanet 2 from our constituency and in a couple of different constituencies, actually. So one of them documented the concern really well, so I'm just going to read and leave the school's name out of the language. So many schools have worked to ensure accurate professional licensure disclosures are provided to students, ensuring that they can make an informed decision about their education and future career plans. Yet the proposed language requiring institutions of higher ed to guarantee that licensure prep programs meet the educational requirements of every state in which the programs are offered as a condition for receiving Title IV is far exceeds the bounds of what institutions can reasonably accomplish with a degree of certainty. Specifically, the requirement would necessitate, 1, the development of compacts and agreements among state licensing boards, 2, cost-prohibitive research and subsequent revisions to the institution's curricula to ensure each licensure program meets requirements for licensure in all states, territories where the programs of offers, thereby increasing significantly the cost of attendance, the number of credits required, and the time to the degree. Or 3, the removal of the program offerings from state for which the programs do not meet the requirements, therefore eliminating the students' freedom to select the institution of their choice. The institutions recognize the concern that students might be unduly disadvantaged if they were to complete a program that may not prepare them for licensure in a certain state. Current disclosure and reporting requirements provide students with a structure that reasonably ensures that they are informed of requirements that may affect institutional choice. Like many of the peer institutions, licensure prepares licensure disclosures in order to provide students with current licensure information. Requiring institutions to guarantee that their programs meet licensure requirements for all states, territories places an incredible burden on institutional resources, when in fact the burden belongs to the state licensing board themselves to improve consistency among and transparency within their license standards. Because state boards change licensure requirements with such frequency and without notice, it is nearly impossible
30 seconds, Kelly.
for institutions to ensure consistent compliance. Further, as such, makes institutions liable for the students' and graduates' performance on professional examinations, leading to exam-driven or restrictive curricula that only serves the most stringent state requirements or reduces potential enrollment for further exacerbating resources and funding. Finally, if an institution were to modify its curriculum to ensure it meets a myriad of licensure requirements in each state, it would be impossible to maintain traditional number of credit hours to degree. Total credit hours, time to degree, and cost of attendance would all increase as a result of the proposed regulations. Thank you.
Laura, you're up.
My comment is initially on Romanet 1, and I mentioned this during the last round of negotiation, and nothing really changed to resolve it. So I support Romanet 1, but I want to make sure that we have language that addresses the fact that new programs are not accredited before they are functional. So there's I can't speak for every single programmatic accreditor, but I can speak for many of them, that's just not how it works. Many of them actually require a program to be up and running, to be functional. That's how we look at outcomes, to make sure it's a good program before we confer full accreditation. Some accreditors have pre-accreditation, provisional accreditation, they may have applicant status, all of those kind of early statuses that a program may have. They're not accredited, but it shows that they are in good faith working through the process to become fully accredited. So I think it's important to sort of align this with some of the provisions in 602, so that accreditors can, can serve the role that they're supposed to serve here, the way that we do our work. So I don't have necessarily a language proposal for that, but there definitely needs to be an acknowledgement that the program has to be working through the process with the accreditor. It could be that the accreditor somehow certifies that they're working through the process. But we are not in the business of handing out accreditation when we have not seen have outcomes.
Thank you, Laura. Adam, you're up.
Yeah, I just wanted to speak again on the transcript withholding issue. Our office, and I know other AG's offices, have had a number of complaints around this issue historically. I think, there's been some comments in the chat about this not being the forum, but the concern is that there's language in this section below that would only prohibit transcript withholding for institutions that are at the risk of closure, which would potentially give tacit permission that institutions can use this practice in all other scenarios. So I do want to just reiterate that, our office believes this is a sharp and unfair debt collection tactic. The states have tried and have started regulating on this issue, including Minnesota, in prohibiting this practice as having unfair and discriminatory effects. Obviously, Minnesota's law is undermined when an out-of-state school through an interstate compact is entering and enrolling students in Minnesota without following that requirement. I do think this is going to continue to be an issue, and the department, when it comes to giving financial aid and conditioning financial aid, shouldn't be on the wrong side of this issue. Schools have an extraordinary amount of leverage over students in this regard. When students have made huge investments in their education. There was a suggestion in the chat that some schools have an obligation to collect debt. Well, I don't think any of those requirements specify the manner in which they collect debt. And so when there is an unfair and harmful practice, it should not be followed, and ordinary debt collection procedures which have laws and protections are available. Again, this is about students that have taken out federal student loan debt, completed their coursework. The department has made their investment in the student. It seems like a basic expectation for access to federal financial aid that schools be required to provide that transcript for coursework where the student has made that, where the department has made that investment. Thanks.
Greg, I see your hand up. Let's respond to that.
Yeah, I just wanted to address a couple of things here. First, with respect to the transcript issue, and we will be discussing that, as was just pointed out in E, where schools are at risk of closure. But to the issue at large about whether or not institutions, whether or not we should prohibit institutions from withholding transcripts for payment, we are considering that. We're looking at it. We have to a number of things we have to look at, including legality. So we are aware of the concerns at the table. We are looking at it, and I'll come back with a more official position in March. But right now, we're still in the process of internal discussions on that particular request. With respect to 32, Romanet I, the programmatic accreditation and seeking accreditation, I can say that we encourage institutions to support their students if not yet eligible for Title IV. However, given the risk an institution may not obtain the programmatic accreditation that it seeks, we do not believe it is appropriate to commit Title IV dollars to those programs. Again, because of the prospect of the potential for that program never to receive its programmatic accreditation. And with regard to Romanet II, that satisfied the applicable educational prerequisites or going back to in each state in which the institution is located or the students enrolled by the institution are located. We do understand that it adds an additional burden to institutions to make certain that the program meets those requirements in each state that students are located who take the program. However, I do want to point out that this is limited to instances where the states that seek employment in that state, there is a licensure or certification exam that is required for the student to practice or find employment. So that student is taking that program ostensibly to meet those requirements, to practice that to practice in that profession, which requires licensure or certification. We believe it is incumbent upon the institution, if offering that program to students in this state, and this would primarily occur, I suppose, with distance education, where you are outside the state where you're located. That yes, it does become potentially burdensome if you're offering this education to students in, say, 30 different states, but that is the institution's decision to do that, take that step to offer that education via distance in all those states, and we feel it's incumbent upon the institution then to accept the responsibility that comes with that, which is to make certain that this program, which is being offered in order for students to specifically secure that licensure or certification, can get that with this program.
Thanks, Craig. Appreciate it. Let's see, next is Marvin. Go ahead.
Kind of two issues, I guess, I want to talk about is I put some comments in the chat on concerns about transcript withholding, and the state of California prohibits this. So, but I think there's only maybe one other state that's doing that right now, and I just think this deserves a lot of discussion, and I'm afraid of the unintended consequences of collection agencies harassing students. Is that worse than you know, them not being able to get a transcript? A lot of students don't even want to get their transcript, and I do feel for the students that are subject to R2T4, and that's a whole other issue, that they didn't plan on paying any money and then they suddenly get a debt. And I just think there's so much complexity to this issue that I think it deserves a whole other discussion, and I don't want to appear like I'm not a student advocate, because again, California is prohibiting this. Maybe that could be looked at as a model. On the second point, maybe I'll have to get back in line because I don't know if we're going to keep talking about transcript withholding, but you know, four-year colleges are very concerned about the expectation that they determine licensing in all 50 states to offer programs, and I just think that it's already been said, and again, we're mixing up two different issues, so I'll shut up now.
Marvin, thank you. Amanda, you're up.
Great, thank you. Just, well, to the Education Department and Greg, thank you for confirming and taking up previous speakers and negotiators' comments about transcript and committing yourself to taking that back to Ed and hopefully conducting a thorough analysis. As you heard, this is one, a large significant problem, potentially even 10 times more, you know, the vision of this station potentially solving this problem, you can impact millions of people, which I would assume is the Education Department's ultimate goal. Another ultimate goal, I think, is social equity impacts here. You know, we're trying to decipher that here in this specific topic when it comes to transcripts. I just want to like highlight that those, you know, the 1%, however many students, close to 200,000, you can potentially say while we maybe not have the hard data and facts that who those students are, they're potentially more likely to be students who are first generation, potentially parents, students who tend to be older, or having a family, Black and Latino students, and other underrepresented students in higher education. Oh, and, you know, some research suggests that some of the lowest payments are about like 200 of their debt, and maybe to some disconnected from this issue or does not come from a family or generation that has lower median incomes, which tend to be students, may not understand why a $200 debt payment seems insignificant, when actually for those families and students who have low median incomes, $200 to $400 is insurmountable and could potentially waive off their entire opportunity of education or economic mobility because they have to pay for increasing costs, not just for their education, but outside living costs. You know, someone once told me that no one can take your education away, but that's not necessarily true. Not true in this case, because transcripts really are a way for you to further your education. And we know that also with lower income communities and Latino students and Black students, is that transcripts, we know that they don't necessarily go the traditional route of straight into a four-year degree. They're more likely to enter more than one institution to accomplish their career goals. And they need that transcript to accrue more credits to finish their finally
30 seconds, Amanda.
additional degrees. So because we know that there rates for this population, lower transferability, we need to solve this problem. And yes, I understand it's complicated, but the department truly needs to put that forefront in their mind.
Thank you, Amanda. Debbie, you're up.
Thanks. Most of what I wanted to say was actually some of the points that Greg had just made. So we'll definitely just thank him for those comments regarding paragraph 32 and the importance of those. I would also just want to address one thing that I think I heard Kelly say in her in the email that she was reading. You know, I think to the extent that this would have widespread new burden on institutions, that would seem to suggest that institutions are currently routinely and knowingly enrolling students across state lines in programs that they are aware will not prepare students for employment. So to me, that underscores the importance of these provisions.
Yeah. See, Armand, you're up.
So I want to address both the transcript issue as well as section 32 Romanet 2. With regard to transcript withholding, first I want to acknowledge the thoughtful comments that Marvin and other colleagues have made about some of the complications here. But what really alarms me about the civil rights implications, I don't think middle-income people understand the gravitational force of poverty and what poverty can do. Simple things that maybe a middle-income person sees as an inconvenience can checkmate a low-income family's ability to move forward. And I do see this issue of withholding transcripts as basic terminating somebody's entire journey through higher ed because they are stuck. They had no way of anticipating the debt. The debt is unrepayable, and the student's entire future is being held hostage to the payment of a debt that could ironically be repaid downstream if they're allowed to access higher ed and enhance their wages. So I really hope the department takes a broader view of this and its impact on communities of color. We heard a lot of eloquent comments about the disparate impact of racism in our society, of the impact on African Americans within the job market. You know, racial justice isn't only a good idea when it's convenient. You have to do it when it's also inconvenient for you. And that's an example. Apropos number 32 and Kelly's comments, Carolyn and I were sort of instigators of this language. We were approached during the break by our colleagues at WCET and WICHE. They did not seem to have a substantive problem with this. Rather, they raised the legitimate issue that maybe the language the department is using of requiring institutions to ensure programmatic conformity may be a challenge in those states where the requirements are unknown or unknowable. And we will attempt to submit some language to that effect, but I did not hear from them, and I generally defer to them with regard to their judgment of what is entirely unworkable. I did not hear from them that the substance of this requirement is unreasonable. After all, the institution is choosing to go into a state to deliver services to people that it knows reside in that state
30 seconds,
specifically
for professional purposes. So it seems to me that professional licensure makes a lot of sense there. Thank you.
Okay, Carolyn, you're up.
Thank you. A couple of points, and Barmack, thank you. That was really very helpful and on both the points. With regard to the transcript withholding issue, just a quick point that it was raised in the chat, but just for anyone missed that or is watching and doesn't have access to the chat, there was a suggestion that we might look to California as a useful model, and just wanted to reiterate that some proposed language that was put forward by myself and a number of others was actually based on the California statute on transcript withholding. So we hope that that would be useful to take a look at. And also wanted to echo support for the department's proposal in 32 regarding the licensure requirements. I think it's absolutely critical, and students put a lot of trust in their schools when they sign up for a course, that it will prepare them to be employed in their state. So I think this is extremely important. I'm very glad that the department has taken this proposal and made it here. I think it'll add enormously important protections. And just one other point here, we have proposed, and think it fits well within this 32, some additional language that would also require that when when schools are going to be offering programs in multiple states, that they should also comply with the state consumer protection laws that are in effect in those states as a sort of a reasonable protection to make sure that students can get protection whether they're online or whether they're brick and mortar in a particular state. And we realize that that can be a complicated issue because of the way that reciprocity agreements currently work in our country and in most states except for California. And so that's why we added some language there to make it clear that where there was a reciprocity agreement in place, then there would be an exception that laws related to the state authorization, such as like an application fee or et cetera, would be exempted out to take that into account. And I just wanted to flag that as something that we have proposed for this section.
Thank you, Carolyn. Before I get to you, Kelly, I just want to mention that the department has addressed the transcript withholding issue, and that we request that you keep your comments to the section that is currently on the table. So with that being said, Kelly, you're up.
Yeah, I would just like to respond to Debbie and Barmack's comment about Romanet 2. And I'm not an expert by this in any case. I'm going based on information that we received over the course of the last month. I don't think that it's fair to say the schools are knowingly offering programs for students that don't meet the licensure requirements in the state. I think the concern is that it's limiting the student's choice. So for example, if a student, if an institution is in Virginia and a student wants to take a course that a university in Virginia is offering, but they live in Georgia, and that University of Virginia or the school in Virginia has said, we do, disclose, we don't meet licensure in that state, but the student knows that, wants to take the course because they're moving to Virginia. So I think that's more of the concern, is the logistics around it. I don't think that four-year institutions are knowingly offering licensing programs. I can't obviously attest to that, but I don't think they're knowingly offering programs that don't meet licensure requirements. I think it's more that the students have the choice to attend that program with the disclosure requirements that are there that states whether or not it meets the state, because you don't know where the student is going to move or where they want to be. So I think that's where the schools are coming from. And obviously, the additional requirements and burdens that I talked about. Secondly, I've been quiet on this whole concept of withholding transcripts for balances because I didn't feel that it was part of this neg reg that we were talking about. And I am sympathetic to students who can't move on in their careers or in their education because of them. Believe me, I am, especially for small balances. But when you get into the larger balances, those students received education and they received credit as it relates to those balances that they owe. And Marvin did put in the chat about the whole context of, the changes that schools would have to be made if schools didn't withhold those. You know, you're talking about going to collection agencies early. Schools don't like to go to collection agencies with students because that affects them for the rest of their lives, you know, and can affect their credit go forward. So, you know, withholding the
30
transcript
seconds, Kelly.
to try to work with the student on collecting a debt that they actually received education for and credits for that they ultimately could transfer to another university. So, you know, I'm not going to belabor it. You know, if it's something that is put into this neg reg, you know, obviously there's more conversation to be had about it, because I think some of the percentages.
Your time is up, Kelly. Thank you.
Thank you, Kelly. Do we have Laura up next?
Thanks. So I get that this issue is arcane, and I'm the only one speaking to it. However, I do need to say again, Greg, you've got to understand how accreditation works. I fundamentally support the substance of what you have in 32. I want to say that. You've at least got to add pre-accreditation into how it is written now, because if you look at CFR 602, pre-accreditation, the department recognizes accreditors to confer pre-accreditation. We have to have it in our scope of recognition. There are requirements that programs have to meet in order to get accreditation. That's got to be in there. It's a fundamental misunderstanding, and the words are important. And I feel like when I'm saying this, the response is always, we feel like it's important to be accredited. Of course, I feel the same way, but we don't want to not include words that make that a possibility. So I get that I'm probably the only one that cares about this, but it is important in order to avoid unintended consequences for programs. I mean, you'll essentially say that there can be no new programs, which I don't think is what the department is trying to say.
We'll take that back with us. Again, you're right, our overriding concern is for the possibility of students being in a program that doesn't eventually receive accreditation. And although that might not be the norm, it is a possibility, but we'll take back the suggestion that we add pre-accreditation.
Johnson, you're up.
Thanks. Just going back to the licensure thing, you know, I view this as kind of having watched a lot of YouTubes of promotions of for-profit schools that then go bust and trying to get loans forgiven. I mean, they're constantly, you're seeing people working during the day and going online and studying for a degree at night. And I think that this provision is going for that. And with all respect due respect for what Kelly has said, I think the four-year institutions are not the people that this is designed to police in terms of licensing and so forth. So I think it's really important if you're reaching out online across state borders to think about whether your student there is going to have any chance of entering that profession. I would think that if you're, you know, having gone to law school that had a very low bar passage rate, people start looking at what do we have to do to make sure our students access the profession that we're training them for. And so it would seem to me an institution needs to know what the licensure requirements are in another state if they're taking students from that state online.
Thank you. Before I get to Debbie, I do see Greg, you have your hand up.
Yeah, I just wanted to address one final time, just to say about the issue of transcripts. We have heard what people have said on both sides of it. It is not currently, you know, up for consideration in the package we have before you, which is not to say that we're precluding it. It's just that we still have to think about you know, what we're going to do with regard to it. So I think we've heard the arguments on either side. I don't want to. It's a very important issue, and I fully understand that. And I'm not trying to cut people off or to diminish the passion people have about it. But in the interest of moving on, I think, and I hope we can table that for now. And we've had a lot of great comments about it. The department has a lot to consider. So I just want to point that out. And when we get to E, I know, of course, we'll bring up the release of hold on transcripts for institutions that are at risk of closure. And I'd like to ask you to consider that in the context it's written for just for what is in E at this time, understanding that there are a range of opinions and that the idea of prohibiting the withholding of transcripts is a very popular one among many of you, just to restrict what our comments will be when we get to E to that specific circumstance. Thank you.
Thanks, Greg. Appreciate that. Just want to echo that that we have had a lot of comments on the transcripts, but we're going to be moving on and address what's on the table. So with that being said, let's see, Debbie, you're up.
Thank you. And I wanted to come back on the question of choice. And Kelly, thank you for the response and the clarification of what you think that some of the concerns are. I mean, I think we have to think about this not just as a question of student choice and whether the student has every institution that they could choose to enroll, but this is also a conversation about federal Title IV eligibility. And that's a choice of where federal taxpayer investments are going to pay off. I think if we're worried about the student, I can't remember which order you had them, but if the Georgia student who wants to enroll in a Virginia institution because they're moving to Richmond, I think you could think of some sort of solution like, allowing a student to submit a handwritten attestation that they understand the limitations of licensure requirements or any associated restrictions, and they're choosing to enroll anyway for that purpose. But I think en masse, I don't think it's either good for students or taxpayers if students are routinely enrolling in programs that aren't going to provide them sufficient preparation. And I do believe it's the responsibility of the institution for understanding those requirements.
Thank you, Debbie. Brad, I'm sorry, Barmack. Sorry, two B's. Barmack, you're up, and then Brad.
We get mistaken for each other all the time. Back to 32. I appreciate the fact that my institutional colleagues don't spend most of their day the way some of us do looking at giant cases of fraud. But it's really important to understand that vague hypotheticals don't actually trump known facts. The case of the Georgia student enrolling in a program that does not meet their future intended residence in Virginia does raise the question of why did they choose that program since it's online. This is not the student going to Virginia. This is really only intended to deal with distance education. So that's the theory, and it makes you kind of ponder how many of those cases are there. The more typical case, of course, is an institution sitting in one state, delivering subpar, entirely inadequate education everywhere else, and then hanging its hat on the fact that the education meets the criteria in one state. We have examples, I cited this, of loss of a particular law school, but a subset of law schools that deliver what is labeled as legal education nationwide, even though they do not have ABA accreditation, they do not meet, their students cannot sit for the bar exam in any state except the state of California. And of course, the nationwide delivery is all predicated, I suppose, on the theory that all these students are intending to move to California, which is decidedly not the case. This is really not, I think the substance of this should not be a problem for legitimate institutions. I do concede that maybe the word ensure needs to be modified a little bit, and we will work on language to address that concern. But I really have a hard time seeing somebody objecting. The school is in a far better position to know what the criteria in various states are than students. And disclosures don't really cut it and they haven't worked. So that's my comment on 32.
Brad, you're up, and then if we can move on from there. Okay, take it away.
All right. Well, I thought I was going to make it through without a comment, but I with some of the comments with Laura back and forth, I got to come in and support Laura on this. She's 100% right. We've got to add the pre-accreditation for folks in higher end graduate healthcare programs. PA, for example, you don't receive full accreditation until 5 years after your first class graduates. That's 7 years after you start the program and about 10 years after you submit your first application. So that's just one example. DO's got its own rules. DDS programs have their own rules. DPT is also 5 years after graduation. So again, CAPTE requires that. So we've got to change that. You can't delay someone 7 years based on not having the pre-approved, I guess it would be the pre-accreditation. So that's very, very important. So thank you, Laura, and I support your comments.
Laura, do you have anything new you'd want to add?
Yeah, just real quick, I also, because since what Brad said, you know, it could be 10 years for some agency to get full accreditation. I did want to clarify though for the committee that during those 10 years, that agency is intimately involved with that program. It's not like, oh, get pre-accreditation and then get accreditation in 10 years. Not like that at all. During that pre-accreditation timeframe, the accrediting agency is monitoring and monitoring and monitoring, and the institution is doing report after report, and there's decision after decision at interim points. So I did just want to make that clear that it's not, you know, 5 years and see you later. It's a very involved process, which is why I support adding pre-accreditation.
Thank you. All right. Right. Where would you like to go from here? Where do you like to pick up?
Yeah, where do we go from here? Let's take a temperature check on B. That was all of these provisions that we just discussed. So on 668, 14B.
Can you clarify? So this would be 3, 26, and 32 that we've been discussing.
Yeah, we have been talking. Remember, I broke up the discussion because there were so many of these, but we have yet to take a temperature check on the starting in 668. Find it here. So there's 668. All of these stemmed from B by entering into a program participation agreement. That was 5, 17, 26, 32.
We're taking a temperature check up through 32, correct, Greg?
Right, up to the end of B, up to
The end of,
up to the end of B, to 32, where E begins, right?
got it. Up through E.
Right.
So, all right. Can we see thumbs? Hold them high. I think I see 5 thumbs down. Would anyone like to make any comments on the rationale for the thumbs down, or are we good to go? I see. There you go. We have 2 hands up. Go ahead, Ann.
I think there might be more clarity on why people are voting, how they're voting, if we were to take these separate by number, because my no vote is based on 26, right? So I think the department would get greater clarity that way.
I can do that. I mean, normally I like to go by paragraph. I can do that, but I don't think we have time to entertain a great deal of additional discussion about each one of those if we do that. I'm willing to break them out, but we just don't have enough time to spend another half an hour on this section.
So Greg, to do the do temperature checks on each of those, but no comments on them.
Right, so we can start with there was discussion on 3 if we want to do 3. That's the institution's program participation agreement. This must be signed. I'm sorry, that's A. I'm sorry about that. We're going with 5. I'm sorry. We're starting with will comply with the provisions of subpart L. So we're starting with B5. This is entirely B. I misstated that.
No problem.
So starting with B5.
Okay, can we do a temperature check on B5 and reserve? Brad, or I can't see your thumb. That
So it is just that one word on B5, or is it up through B5? I'm sorry.
It's B5, and it's what's in B5. It was just basically we just changed it to subpart L. So, but if everybody wanted to
Just
do it,
making sure.
yeah, that's all it is. If you don't like subpart L, then I guess you're.
all right.
I wanted to vote on the fax machines earlier.
No fax machine votes.
I'm voting thumbs down on fax machines, even though it's our suggestion.
Full thumbs up approval on the fax machine, I think.
All right, Greg, I assume 17 is next.
17, yeah, 17 is next.
All right. Quickly, if we could, everyone. Let's take a look. I don't see any thumbs down on 17. All right.
26.
26. We'll just say several thumbs down and no comment on those, as we talked about. And then
32.
32, yeah, thank you. And there are a few thumbs down on 32.
We didn't vote on 3, but we had a lot of conversation on 3. Do we need to vote on 3, or does it matter?
I think we have what we need. There were no changes over that there. We have the comments, so I think we'll just we'll move on.
Yeah, thank you. So now we're going to move. Greg, I'll turn it back to you. We're on 32. Is it E?
We're at E, and Renee will bring up paragraph E. Thank you, Renee. So starting here with E, we have, and let's see, the first one we're going to take a look at here would be under E1, at negotiator's suggestion, we have added some language regarding the teach-out plan to be acceptable and ensuring that it will also be provided to our partners in the state. So you see that reflected under E1 Romanet 1, submission of an acceptable teach-out plan or agreement to the department, to the state, and to the institution's recognized accrediting agency. And then we move down to Romanet 2. At negotiator's suggestion, we have added some language regarding the, that's what we already did that. That's not what I want to do. Not what I wanted to do at all. Oh yeah, we, at negotiator's suggestion, we have further specified that the records for the records plan must be acceptable, that it must include a plan for student transcript and other Title IV records, and that the institution must implement the plan and demonstrate that implementation. So you see that reflected in Romanet 2, submission of acceptable records retention plan, including but not limited to transcripts and other Title IV HEA records to the department, and evidence that the plan has been implemented. And moving down to, at the risk of stepping into dangerous territory here, down to Romanet 3, at negotiators' suggestions, we have broadened this item to include more transcript holds. You can see what we did there, the release of holds on transcripts. And we removed the reference to over de minimis amounts. And then moving down to, okay. Yeah, moving down to 5. We have updated the text to use more standard language on financial protection. So you can just see there that we have eliminated shorty and just change it to financial protection to make that uniform across all of our regulations here. Moving down to 6. At the negotiator's suggestion, we have added a reference to student complaints here. We also note that this is a non-exhaustive list, so additional reporting requirements, which may include but are not limited to cash balances, an actual and protected cash flow statement, student rosters, student complaints, and interim unaudited financial audits. And that is it for E. So I'll open the floor for discussion on 6814E.
Let's see. First, I see Adam. You're up.
Yes, I appreciate the admonition around not discussing transcript withholding. I just wanted to point out that I think, like, you know, when I'm considering this part, I think it's impossible to not consider, you know, the broader impacts around transcript withholding. And so that's kind of part of it, but, you know, what's been said on that has been said, and I think it's part of this discussion. When I'm probably going to vote, you know, thumbs down on this, and the reason would be because of the implication around transcript withholding being permitted in other circumstances. So I just wanted to put that out there, and I won't say anything more about transcript withholding.
Thank you. Before I get to Johnson, I just want to mention that Jamie is back for accrediting agencies. Welcome back. And Johnson, you have the floor.
Yeah, so the literature I've read on transcript withholding that where other people have dug into is the secretary has never issued a regulation on it. So this would be the first mention of transcript withholding as anything. So I wouldn't want that to be a precedent here, especially since we've been talking about having a larger discussion about it. That may be better to omit it completely, even though I am empathetic to the people who'd be affected. It just would be a bad precedent.
All right. Let's see, we have Barmack.
So I submitted the report from the National Student Legal Defense Network for the department to review. The component of it that I think is relevant here has to do with the statutory basis for, in this case, the 10% surety that the department may require of institutions. As you will note in reviewing that memo, the statutory provision, section 498C3A of the HEA reads, not less the only reference to this construct is not less than 1/2 of the annual potential liabilities. 1/2, 50% of annual potential liabilities, not last year's most recently completed fiscal year, but future looking. And the department has deviated from that statutory text, both with regard to percentage, in this case, as well as what that percentage is indexed to. So that's one issue. Again, I'm not an attorney. I raised that. I submitted that for the record so that the department would have an opportunity to address it. But even leaving the legality question aside, why would the department not want to receive adequate protection against the possibility of loss? I mean, the department has time and again, Vatterott, 12 years on provisional certification, $242 million of losses, and the department held a 15% letter of credit that really only covered a fraction of the amount. Why wouldn't the department want to do what any prudent lender would do and look at the totality of the liabilities that this entity may owe it and require a surety that is adequate to the level of risk that it's undertaking? I don't understand why, after having been burned this many times, why are we still doing this sort of de minimis, timid kind of oversight?
Well, I'm sorry, and we have here that, you know, I would point out that the amount determined by the secretary is not less than 10% of the volume for the prior fiscal year. It does give us authority to request to require more than that. But you're suggesting that we require ourselves to regulate ourselves to 50% of total liabilities, or?
Well, I'm not requiring that. Congress requires that. Congress has set that percentage arbitrarily, I admit, but that's the law of the land. And yes, you do have the ability, and I encourage you to use that ability, but in articulating what you index that 50% to, why are you looking back as opposed to the future? Why are you basing it on past year when the statutory language references potential liability in the future, not what they owed you, well, not what they did last year, but what they look like? And remember, this is a case, this becomes very relevant in the case of institutions that are in distress and have every incentive. If you know you're going to go out of business, you may floor that pedal and just go for broke. You might have, that may well be your only Hail Mary at that point, is to enroll as many people as you can and take in as much money as you can. So it seems to me like you really want to, just out of prudence, not even out of legality, you really want to do a full assessment of what the liabilities, and not just Title IV, frankly. Congress says Title IV, but I would look at the totality of the liabilities this entity is facing.
Thank you, Cormac. Brad, you're up.
Yes, I've got several questions in this section, but I'll start with an easy one, and this is just truly an operational question here. I'm not saying I disagree with it. So E1, Romanet 1, the submission of teach-out plan or agreement. So does that just mean submission is okay, or do all three have to approve, or do all three, is there an order you have to go through? I'm just not sure if the word acceptable means you have to get it approved, or how that was going to work. So maybe help me out with that. Those aren't easy. I mean, those are three big different entities there.
The regulation is the acceptable teach-out plan would be, as it says here, submission of an acceptable teach-out plan or agreement to the department. With respect to the teach-out plan and Title IV funds, it would be the department's decision as to whether it was acceptable. Of course, that would be for our purposes. States could also, I think states could step in there as well to determine whether they believe that it was acceptable to them. But as you know, for these regulations, it's acceptable to us, and would have to be that would have to be submitted to the state and to the institution's recognized accrediting agency. So once it's been determined that that teach-out plan is acceptable, it must be submitted to all of those entities. The intention here was to make certain that all of these entities had the teach-out plan.
All right, and then so just to confirm, so the department's the only one that has to approve it. Just submission to the state and the regional accreditor is acceptable, is the way the way you just described that. Right? They don't have to.
Well, I'll ask Steve to weigh in here. That has to be acceptable to us. I don't think we can preclude a state from saying that they don't find a teach-out arrangement to be acceptable. I'm not sure what impact that would have on the teach-out arrangement as it is accepted. If it were to be accepted by the department, but a state were to say this is not acceptable to us, what ramification that would have, I'd have to take that back, unless Steve has a comment on that.
Yeah, I mean, I'll just add the department is usually working with the state and the accrediting agency on these issues. So in a large part, whether it's acceptable to the department is likely to hinge on whether it's acceptable to the accreditor and the state. We're usually not the lead party on hammering in the terms of the teach out.
Okay, all right, so I'll defer to the state folks then, but I think you answered that question. 7, real quick, it's a simple question here. Limitations on an institution in a written agreement. I just want to clarify, does that mean new agreements going forward? Does entering into mean new, or is that, so existing agreements are okay? In 7, as I read it, that's the way I read it, I guess. So my question is, I'm confirming that. If you've got an existing agreement with another institution, that's okay. You just have limitations on anything that's a new agreement. Can you confirm that?
I believe that's the way it's written. I will get confirmation of that, but it does say limitations on institutions entering into a written arrangement.
Okay, perfect. I'll get back on
that's going forward.
Okay, thank you.
Jamie, before we get to you real quick, I want to announce David Sokolow is in for state agencies. Jamie, take it away.
Yep, 2 quick points. Underlining what Steve Finley said a moment ago. While the department can decide when it is satisfied that the teach-out plan is acceptable, accreditors may have their own determinations that they choose or are required to make about the acceptability of a teach-out plan. And as he said, the department may take that into account when it makes its determination of acceptability, or we may go first, or we may even coordinate on that. Second point, I hate to raise the word transcript again, but I was surprised, if I understood I think it was Adam and maybe Johnson, why you would object to the inclusion of the transcript item here, recognizing that if a broader solution is addressed and covers this and this is no longer necessary, it could be eliminated. But why wouldn't a step that made it possible for the department to address releasing holds on transcript here be a positive step, recognizing that this provisional situation may be a special one, and you know, take that one step, and if it's possible to identify a broader step, then you know, double back if this is no longer needed.
All right, moving on. Let's see, Ann, you're up.
Thank you. I have a question about number 3, restrictions on the rate of growth and enrollment of students or of Title IV volume. And so recognizing that these are colleges that have already, or institutions that have already been determined at risk of closure. Just the phrasing there, the growth and enrollment of students, is there a reason it isn't just more simply restrictions on the enrollment of students or of Title IV volume or loans? I mean, the way it's written, it's almost assuming or even promoting the potential growth of institutions that are at risk of closure. And given all of the discussions we've had about the students who are at risk, if this is an institution that the secretary has already determined is at risk of closure, I think the last thing we would want is any growth, let alone, I don't know why we're restricting the growth.
I think I can address that. Well, okay, so here, if we start at the top of E, this is, we're talking about provisional certification in general, and one we did for that was for institutions the secretary determines to be at risk of closure, and then we move down to the rest of these numbers. So I think that with provisional certification, there could be a lot of reasons to provisionally certify an institution. I think it would be perhaps a stretch to say that every time we provisionally certify an institution is because we believe that there's an imminent risk of closure, although that might be the case. Under restrictions of growth, this just enables us to look at a school that is on provisional, and it doesn't mean that we are expecting or accepting a large amount of growth, but just restricting part of that growth. Generally, what this involves, and Steve has worked a lot more with this in the field than I have, so I will defer to him. But for instance, we might prohibit a school from adding additional programs while they're on provisional certification, just because we have concerns about maybe their ability to adequately administer aid for the programs that they have. So these restrictions on growth or volume are to deal with that. Most of the ones that I've seen have to do with the restrictions have to do with adding additional programs for those reasons. So it does, in most cases, it doesn't mean that because we say restricting the growth that we're going to allow a great deal of explosive growth with just these restrictions. I think it should be looked at in terms of things that ordinarily an institution would be able to do once it's fully certified, such as add locations or add programs where we just restrict those two things. So I think in large part it's programs and locations, but I'll let Steve add to that if he wants to.
Just a little bit. I mean, there's relative concerns about closure and the imminence of closure, right? And if you've got somebody that really is, there's a concern that it's week to week. I mean, the rate of growth, the acceptable rate of growth there might be 0, right? That is a rate. Maybe it's an irrational number if you're dividing, but it is a rate of growth for somebody that's in imminent harm of closure. So this is just creating a touch point to note that these limitations can be applied to deal with situations of concern.
Steve, we have Brad up.
Well, that's a great lead into my question, Greg, and one of my favorite things. So I'll leave alone the fact that 2 and 3 are still undefined, but Ann made her case. But I want to go to my favorite topic, number 8. So for an institution that's been alleged to have engaged in a misrepresentation of students. So I ran some numbers this morning. I was having fun. Post-secondary education participants. There's 2,406 institutions at the 8-digit OPEID, so that would include branches that are provisionally certified. 2,406. I have no idea how often this occurs in alleging something, but the department operationally that can't get a change of control approved, how in the world are they going to manage this? And just for an example, Grand Canyon, I believe, is provisionally certified. They've got 100,000 students. They get one alleged comment on an ad, and now you're going to review every single ad, existing and new? That would be like a full-time, by itself, department within the department. So help me out on this one, Greg. How in the world can the department manage this?
I don't see what is the 7 as obligating the department.
I said 8. I'm sorry. I said 8.
You mean 7, right? Yeah. I mean, you mean 8.
8. Yeah. It's
right. 8. I'm sorry. 8.
Alleged have been to. Let me just read it. Alleged or have found to be engaged in misrepresentations to students. Alleged. That's not a very hard hurdle to hit, right?
No, I mean, there certainly is, and
2,406 locations that could happen at, and you're going to review every single marketing material.
This doesn't obligate us to review marketing materials in upwards of 2,000 cases. I mean, this is, in looking what this says, alleged to have engaged in misrepresentations to students. It doesn't mean, I mean, the department, I mean, there's always a certain amount of discretion involved with things. I mean, here you have provisional certification, which the secretary does for numerous reasons, and there is some discretion involved in that. The department can also initiate program reviews for student complaints. Do we go and do a program review because of one student complaint? Generally not, unless that was a very serious complaint that we had. But I mean, it's always possible. Students complain about schools all the time. It runs the gamut from every type of school in the country. We could initiate program reviews as a result of student complaints. We don't do so in every case. So again, there's discretion. If 100 students complain about a school, might that precipitate something? Perhaps. Here we're looking at if we see a pattern of misrepresentations to students, what we believe are aggressive recruiting practices, and violations of incentive comp. So I mean, I think for the alleged or found to have engaged in misrepresentations, if a school is engaged in practices that we believe are a misrepresentation, that's a very important thing for us to get ahead of, because these could be instances where students are being given information upon which they have a reason to rely that is inaccurate. They're making decisions about this. So we want to see in that case what types of materials institutions are providing these students with. And it does not obligate the department to review the recruiting and marketing materials of 2,000 institutions.
So additionally, in 8, I submitted language. I do think the word substantial needs to be in front of misrepresentation. Allege is a very, very low bar to clear. And I also believe that we need to delete aggressive recruiting practices because it's still not defined. I'm not against that. but we've got to define it. And we've seen no definition on what that is at this point. And that's come up several times throughout. So I'll resubmit my proposed text to number 8 and into the chat. Thank you.
Thank you.
Thank you, Brad. Let's see, Johnson, you're up.
Thanks. Yeah, with respect to number 8, I mean, having done a lot of discovery against institutions that engage in deceptive practice, they don't give you stuff that you want. The government's giving out Title IV money. It seems completely legitimate for the government to ask you for marketing materials if it feels like it's gotten a threshold of information. I just find that hard to believe. So I support that. With respect to Jamie's question as to why we would be against this. So there are only 2 statements that I've ever found where the Department of Education has talked about transcript withholding. They're in 1998 and 1996, and they basically endorse it. It's in the handbook. So if we go forward and this is never touched on again, we're going to be left where the only time the secretary's ever said anything against it is in this situation. I just don't, I hope we'll address this in a regulatory fashion, but if it comes down to regulation, that may be a court's only information that they have that it's only applicable in extreme situations where a school is in consideration of being shut down, and I don't want that to be a precedent here. Thank you.
We're going to take Adam next. On sections 1 through 9, and then I'll turn it back over to Greg. So take it away, Adam.
Johnson made my point, so I won't have to say anything about transcript withholding. Thanks.
All right, no problem, Adam. Appreciate it. Greg, you want to take a temperature check on E1 through 9?
Yes, we can do that. And I do understand that the reason for some people's, some negotiators providing thumbs down here will be as a result of the transcript. So I'll stipulate that. Okay, go ahead.
Okay, if you could please hold your thumbs high so we can see them. All right, we see 1, 2, 3, 4, 5. 5 thumbs down. Okay, thank you. All right, Greg, would you like to move on to F?
Yes, please. We'll wait for
Renee
to bring that up.
All right, please. Thank you, Renee.
And okay, so we are now in F. The first thing we see in F change that we made was we had an erroneous reference there, and we fixed that. We removed it, rather 66828B as reserved. So that's the only change there. And then we move over to, I'm sorry, a mistake there. So also in F1, no, I'm sorry, mistake. That was all for F1. I just was a little confused there. So then we go to the next area where we have made changes is in F4. So that is the institution may not advertise, that it operates as a nonprofit institution for the purpose of Title IV until the department approves the institution's request to convert to nonprofit status. So we've added this provision as a requirement for institutional advertising when a nonprofit institution seeks to convert to for-profit status. And that is everything for F. So it's not much, but the only substantive one there would be in 4. So in the interest of going paragraph by paragraph, I will open it up for discussion on that.
Okay, this will be on F 1 through 4. Let's see, we have Jamie up first.
Just a simple issue. I have no problem with the piece that says that an institution must be clear about its status with the department. But as somebody who's tried to explain it a number of times, the difference between IRS, a nonprofit designation for IRS tax purposes, and the department's determination about whether it will provide its own version of nonprofit treatment to an institution is confusing. And I don't know if whether there's an opportunity in this rulemaking to consider making that clearer or finding some way so that it's understandable. Because if you looked up, if I made a gift to this place, would it be tax exempt? It is very possible that there's an institution where the answer is yes. The IRS would say you would be exempt. That contribution would be treated as a contribution to a nonprofit. At the same time, the department has not determined to grant it its nonprofit treatment, which has certain characteristics and provisions. I don't need an answer complicated, but if there's my second choice, if it's not possible in regulatory language, would be to give us a phrase so that it's easier to explain for students and their advisors who could be confused about which it is, and so that other regulators know, is it both are nonprofit? Yes, check 2 boxes. One is, one's not. I think could be helpful. But I'm not asking for an answer on the fly, Greg.
Thank you.
You, Jamie. Brad, you're up.
I don't have a dog in this one, but I'm curious on number 4, on the institution may not advertise that it operates as a nonprofit institution for purposes of Title IV. So I just got to ask the question, does purposes of Title IV mean the nonprofit institution can advertise they're a 501c3 for IRS purposes? Is that what that essentially means, that that's okay?
I wouldn't want to say that the regulation provides some type of an imprimatur to advertise in a specific way. I think when you talk about advertising that it operates as nonprofit for the purpose, there becomes a reasonable person test there. Obviously, if you see it, let's make it an easy one. If you see an advertisement for an institution on a television commercial where it obviously is seeking to enroll students, the school also participates in Title IV, and may or may not say, the usual Title IV available for those who qualify or something like that, that there clearly is a tie there. So, and it would obviously be an instance where the institution is trying to advertise its not-for-profit status as a selling point or something for, to attract students. We do say for Title IV purposes, because obviously we don't determine IRS tax status. That's the IRS's determination. But we are saying here that they cannot do that until we are making it clear that there's a difference. Until the department approves the institution's request to convert to nonprofit status, it can't represent itself for those purposes. I don't know that we can take all the nuance out of this, Brad. Would an institution go on TV and say they're 501 C3? But however, for the purpose of Title IV, we are not. I guess they could do that. I don't think you would. I'm not sure that would happen. We'll take the language, we'll take the concerns back and see, and review it. But I think as written, it would be one of those, maybe, you certainly would know when you see it, I think, in most cases, but we will take the concerns back.
Yeah, I mean, for me, I think more people across the country know what a 501c3 is than, for Title IV purposes. That's just, again, but you all, just answer, come back to us with an answer. I really am not up or down on this one. I just thought that was an interesting addition. So thank you.
I mean, you could say for Title IV purposes, or also that, I also want to add here that the department said, we don't consider you a nonprofit until the department has approved the institution's request. I mean, if you're making a nuanced statement, could they advertise that having met the tax status, but then put a disclaimer in there? However, the Department of Education has not approved us to operate as a nonprofit. I think that would have to be something our attorneys would look at on a case-by-case basis.
Yeah, and I think it'd be more prevalent in the Google ads, just the bottom 501c3 nonprofit. Just a quick little disclaimer that would be on the TV ads. So.
Yeah, I don't think we've explored it to that level, but as I said before, we will have a discussion about that.
Hey, Johnson.
Hi, yeah. So I have two comments. I think I really support 4. I haven't run into this problem with clients, but just trying to understand if an institution is a for-profit or nonprofit. You can't tell by the website because they have EDU and they're all treated the same. So you got to go dig around to find out. Most clients don't do that, and I can say that if they see something with an org on it at the end of the website, they may think it's a nonprofit. We get this all the time with scams involving debt relief services, where they funnel people into for-profit entities, but they're a collector of information that then sends them to these places. So, making sure that institutions are, where people are clear what the institution's mission is, whether it includes shareholders or simply education, I think is a admirable and correct thing for the Department of Education to take a stance on. Thank you.
You, Johnson. Before we get to you, Barmac, just wanted to mention that Yael is joining us for State Attorneys General. Thank you. Barmac, go ahead.
I have to confess that I don't have an overarching sense of how the different pieces of these regulations dovetail with each other, if they do dovetail with each other. I'm a little confused with this section because it appears to address interim behavior between approval as a 501c3 by the IRS and recognition of the entity as a nonprofit by the department. Let me ask that, is that correct, or is this something else?
The rule says, and the rule does not obviously obligate the department to recognize it. I don't think it necessarily presupposes that we will, just because of the 501c3 status, that we will ever recognize. It's possible that we will never recognize that institution as not for profit. So I don't think it necessarily means it's always an interim. It's always a limbo type situation where it's always between the one. It could be. There's also the possibility the department will never recognize it as having converted.
Well, this is, look, if it's a nonprofit, if it's a for-profit, triggers a change of status that the department ends up denying, it remains a for-profit, I assume. If it's a for-profit and it actually satisfies not only the IRS, but the department that it is in fact now a nonprofit, then that's a separate set of issues. And the question then becomes, are you imposing some new constraints on that entity based on its legacy status? And then, of course, there is that interim period where the entity is an IRS 501c3, but not yet, no adjudication has been made as to its status with the department. I'm just struggling to understand what this is attempting to address.
Well, what it's addressing is the reality that just because it has the appropriate IRS status to be considered not-for-profit does not mean that we recognize it as such, and they can't.
But why can't you just say that? Why can't you just? That's what I'm struggling with. Why can't you just simply say, you are what you are until we tell you you're something else?
We cannot tell the IRS what it can deem a not-for-profit organization. That's why this is limited to Title IV purposes. And I don't think we can. I mean, even if we don't approve it, they remain 501c3 for IRS purposes, right? It's a matter of what Ed. I mean, with us, I don't really see it as being interim. When they get that status, they can ask us for a conversion of not-for-profit, but until we approve it, they remain for profit, irrespective of what the IRS has, what the IRS is. And I see Steve has his hand up, so I want to defer to him.
Yeah, there is an interim status here where there's a prerequisite that the institution that seeks approval to be recognized as a nonprofit for Title IV must already have the 501c3 designation, right? But this is just addressing that interim period. There's reporting requirements that still apply. to the for-profit entity, because until the department recognizes it and approves the change of status, it is still a for-profit entity. And it is important to address this issue about how advertising its status, because that could mislead students. I mean, that's why that's there.
So just to, that's a very clear answer. So I'm clear. This is not articulating substantive criteria for approval. This is simply addressing that period of pendency during which the department is making a determination whether the applicant is in fact now a not-for-profit entity.
Yeah, I think that's correct.
Okay, thank you.
Thanks, Steve. And Brad, you're up.
Yeah, so in F2 here, we're proposing that this institution seeking nonprofit will continue to meet gainful employment requirements for at least 2 years under its new ownership. Is that a point regulation gets approved? Is it retroactive? What is the intent here on this one?
We're saying the institution must continue to meet the gainful employment requirements of subpart Q of this part until the department has accepted and reviewed. Well, obviously it presupposes subpart Q being the new subpart Q being in effect. So if it's subject to gainful employment rules, we have to continue to meet those requirements for 2 complete fiscal years under the new ownership. Or until the department approves the request to convert, whichever is later. So that's in recognition of our proposed subpart Q.
Okay, so that would be sometime after July of 23, then, I guess, said another way. Would start applying.
If those rules went into effect at that point, yes.
Okay, and then 90-10 not being part of that 2-year. Just curious if that's a regulatory reason or.
Not sure where you are, Brad.
Same point too there. You're saying you got to meet GE for the next 2 years, but you're not saying you have to meet 90-10 for the next 2 years. Just clarifying that's the intent there. These are for for-profits that convert to nonprofits. They had to meet 90-10 up until the conversion date. And then we're saying 2 years after the conversion date, you're subject to GE, which I still struggle with because GE is for profits only. And if you approve them, I don't know how you subject them for 2 years after because they're no longer for profit. But we can argue that.
Yeah, there's no reference to 90-10 here.
Okay, so 90-10 ends once the conversion starts.
Steve, I want to ask Steve about that. It's when it ends. They're subject to 90-10. I'm trying to think, do we have any rules in the 90? Do we have anything in 90-10, Steve?
It's defined in F1 right above it, Greg.
I missed that.
Okay.
Oh, it's the 668-14 reference.
Right. I'm sorry. Right, Steve. What we did there was, thank you, Steve. I see what you're talking about. In which the institution meets 90-10 was struck out, but we have 668.14, which is the program participation agreement reference to meeting 90-10.
Thank you. I should have gone there.
So I'm sorry. Yes, it does.
I just saw
the reference. There is the reference there to 90-10. Until the department approves, until the department approves that request to convert, and it is 2 complete fiscal years.
Thank you. Sorry about that. I missed the reference.
2 quick things. One, Carney King is in for students and loan borrowers, and then we're going to take David, take a comment from David, and then do a temperature check on F12. So David, take it away.
Yeah, it's a question for the department. I know this whole section F is about for-profit converting to nonprofit, but is there any other place where there's contemplation of similar rules for a for-profit converting to public status? Or would this be the right place to put it?
For-profit converting to a public to public status.
Surely the department has considered that prospective problem.
I don't know that I'll take that back with us. I don't know that we have, if we've had discussions about that, that I recall them, but I'll certainly take that back. So you're talking about a for-profit entity that would not only seek to convert to not-for-profit status, but be public, right?
Yes, convert to public status. I mean, I think there's three statuses: public, nonprofit, and proprietary. And you've got one conversion discussed here, and there's another possible thing that can happen.
Okay. Yeah, I don't know. We don't have anything on that. I don't want to speak to that right now until I've taken that back and we have some more discussion about that. But thank you. Could you put that in the chat, please?
Hey, Greg, you want to take a temperature check on F1 through 4?
Hold on one moment.
You want to go to G?
Just hold on a second, please.
Sure.
Okay, I do. Before we get to that point, I want something here. I just was prepared for us by some of our people. I just wanted to say this. When we clarification of our communication, we with conversion to not-for-profit status, we are not restricting institutions from saying they are 501c3. And further, although the department has not yet approved, some phrasing we have here is not yet approved an institution's request for recognition as a not-for-profit institution. The department does not take a position with respect to whether the institution or its owner's 501c3 tax exempt status with the Internal Revenue Service. However, the institution would have to refrain from identifying itself as a nonprofit institution in any advertising, publications, or other notifications. Use of the term nonprofit may be potentially confusing to students and the public, who may interpret the use of nonprofit to mean the department has granted the institution nonprofit status under its regulations. The department does not take a position regarding statements in reference to IRS status, such as 501c3 tax exempt organizations as designated by IRS. So I just wanted to point that would be just some clarification of the department's position on that. So yes, going back to this, we can take a temperature check on, I believe, I'm confused here. F, right? Correct? I believe.
F1 through 4.
F1 through 4, correct.
Mm-hmm. So if everyone could hold their thumbs up so we all can see them, that'd be appreciated. Looks like there are no thumbs down. Correct on that? Okay. Hey, Greg, turn it over to you.
So we will move on to G. In both 1 and 2 here of this section, we've clarified that reports related to agency actions, servicing agreements, and or IRS communications be submitted within 10 business days. While negotiators proposed 14 business days, we have used 10 business days to comport with current agency practice. So we look at, and thus the in G, an institution is initially certified as a nonprofit institution, or if it has undergone a change of ownership and seeks to convert to nonprofit status, the following conditions will apply to the institution upon initial certification or following the change in ownership, in addition to any other conditions the secretary deems appropriate. The institution will submit timely reports on a creditor and state and authorization agency actions and any new servicing agreements within 10 business days until the department has accepted or reviewed or approved the institution's financial statements and compliance audits that cover the 2 fiscal years. And then in 2, the institution will be required to submit reports or communications from the Internal Revenue Service or any state or foreign related tax exempt or nonprofit status within 10 business days, so long as the institution participates as a nonprofit institution. So that's the entirety of G. I'll open it up for comment.
Hey, comment on G. David, you're up.
I just, that same point that I mentioned about F in the chat and mentioned it also, it belongs here in G as well.
Thanks, David. Jamie.
Minor technical question. I did not take the time to go back and determine whether the 10 days matches the timing by which the accreditor is already obligated to tell the department about actions relating to institutions. So A, the department may already be getting this, and is it, just, I have no problem with being sure that you get that notification, but do you need to ask for it if the accreditor is required to give it to you? And do you want and need that extra set of things? And if so, if there's a reason that it is helpful to the department, it might be useful to just check that the 10 business days matches or allows time for the accreditor's notification to then let to the institution to let them notify you.
Not sure quite.
Timing alignment questions to take a look at.
What do you mean about the 10 business days here?
Yeah.
Well, this has to do with the institution's requirement to notify. Must submit timely reports and statement. Yeah, within and I don't. We just change this from. Is there any? I'm just not sure I understand the concern you have with it. I guess
right.
I'm a little confused.
It doesn't say within 10 days, 10 business days of what. So has the accreditor has an obligation to tell the institution, but is it the date of our action, the date the institution must know? I can give this to you offline. I just think that it's a little unclear about within 10 business days of what, because the action and notification date may be different for the school. And you may already be getting this from the accreditor, such that I don't know that you need to burden the school or yourselves on that point. It's a very minor.
Oh, you're talking about when the, so you're saying when the accreditor takes the action, accrediting agency takes the action, and then when it notifies the institution. And currently, as we have it written here, it's incumbent upon the institution, I think, irrespective of what the accreditor does. But we'll certainly take that back if you want to write that up, if you think it's redundant.
Thank you, Jamie. I don't see any additional comments. Greg, would you like to take a temperature check on G?
Sure.
1 and 2?
Sure.
Okay. So if everyone could raise their thumbs up so we can see them on G 1 and 2, that'd be great. No thumbs down on G. Back to you, Greg.
Okay, so we have for the remainder of this section, we have nothing in and here's my favorite lettering schemes again. Nothing in H, I, or J. We've updated some cross references here, which is all that we have done, or in K. So I'd like to move on to 668.43 if we can. Institutional information. And this takes us to the end of the paper, actually. So thank you, Renee, for pulling that up. This is 668.43 institutional information. The change here at negotiator's suggestion, we have added back this disclosure and sought to make it more streamlined. We agree that institutions should assess whether they meet licensure requirements across the country and should make that information accessible to students. And so we're looking in 668.43 A5 Romanet 5. if an educational program is designed to meet educational requirements for specific professional licensure or certification that is required for employment in an occupation or is advertised as meeting such requirements, a list of all states where the institution offers the program and where the program meets such requirements, and a list of all states where it does not meet such requirements. So I'll open it up for discussion on that addition to 668.43.5.
Renee, bring it to you, Barmak. Debbie Cochran is back in for state agencies, and then Barmak, you're up.
We're going to add the word "and programmatic" to this, and to make it conform with the way you had it, you labeled it under gainful, I assume.
What are you suggesting, Barmak? Just to be sure.
In gainful, the same section was called institutional and programmatic information. I assume that's the one that that's the one you're going to keep, right?
Well, this is just. Oh, I see. Oh, you mean in? Oh, I see what you're saying in 40.
Right. The section label, the section name is going to be "and programmatic information."
And programmatic, right? Yes.
Right. Okay,
I see what you're saying. The way it was renamed in the way it was named in gainful employment. Not
right. That's the one that governs.
Right. Yeah. Correct.
On my mute button, I'm sorry. Ann, you're up.
Sure. So just a clarification question. So as I read this, it says, is advertised as meeting such requirements, a list of all states where the institution offers the program and where the program meets such requirements, and a list of all states where it does not meet the requirements. So are you saying that a college or an institution, let me ask this question a different way. Is that second part, a list of all states where it does not meet the requirements? Those are also states in which the institution offers the program, correct? Because that's not what it says.
I understand that, and given what's currently proposed, they wouldn't an institution wouldn't be allowed to have a program offered to a student in the state where it doesn't meet the requirements. So well, I see what you're saying there. We'll take a look at that.
Okay, thank you.
Thank you. Brad.
I just wanted to state in closing that 668.43 is a great place for a GE metric for all students. Thank you.
Thank you, Brad.
Okay, let's see. We have Jamie and then Debbie.
I think Ann's question may have cleared out several kinds of underbrush, but if it were done this way, I was going to ask whether there was a third category, which is we don't know or we haven't determined. But you're saying that, granted, it may be possible that there's, if Montana is not on my list of places where it's offered, I don't have to say it does not meet Montana requirements.
I don't want to say that yet. I want to take that back with us. I think there is a wording issue here with how it's going to mesh with our with the proposed requirement that in order to offer the program to a student in a given who is in a different state, that it would have to meet the licensing or certification requirements of that state. So then, if it's being offered to that student, it necessarily meets those requirements. There could be, but as a matter, but this is a disclosures or information. So I mean, listing to students, to prospective students, that it just doesn't meet the requirements in these states, could well be something useful to students just at when they're exploring which programs they might be interested in. Having a list of states that it doesn't meet, even though the potential for schools to offer the program anyway in those states may not exist, it still would be of interest to students whether or not it meets the requirements in that state.
You may want to consider a blanket if it's not listed here, what does that mean? But if you don't want to demand that an institution, if there are no students and it's not being delivered, go to the trouble of determining it does not satisfy, maybe it does. They just haven't ever had, schools in the Northwest that want it, but it's not a task they have done. They have not made an affirmative determination that it does not meet. What you want to be clear is you cannot assume that it meets any but the ones where we have said that it does.
Okay, we'll take that back.
Hey.
I'm not going to offer specific language because I know that probably need to go back and look at this in light of some of the other issues in 32. But I would really encourage the department to think beyond just certifications that are required, because I think really there are a number of certifications beyond like hard and fast requirements that would practically increase employability, or the lack of which would decrease employability. So I think it makes sense to keep that separate from the types of requirements that are discussed in paragraph 32, but I think it is still important consumer disclosure.
Thank you.
Kelly, you're up. Thank you.
As it relates to 5, aren't these disclosure requirements already required in 668-43? So I guess I question why we're adding them again. I mean, in light of the conversation that we had earlier as well, I mean, I don't necessarily think the constituency I represent agrees with this, but these disclosure requirements are already required.
Yeah, I think let me take this back, and I want to go back and review those other areas of state auth and 43 before I comment on that.
Thank you.
Thank you. Blade Johnson, you're up.
Yeah, I just want to agree with what Jamie said, which was essentially if you're not reaching out to students in other states and you have no history of it, this is more. There are lots of disclosures. You don't want to not only burden the institution, but you don't want people just to stop reading disclosures. So I did read this being fairly encompassing of obligations here. I would just try to change the wording so it doesn't unnecessarily burden things. On the other hand, as Barmack gave the example, if you want to go to an unaccredited school in California and you're going to do it online, you're not going to be able to sit for a bar exam anywhere else. And people should know that if they're doing it online, obviously. So,
Johnson, Marvin.
Yeah, I just wanted to make the point that I think the unintended consequence of this is making four-year publics think about whether they really want to offer programs with the burden that would go along with this requirement. So I think that's a major concern, and I understand what you're trying to do, but there's maybe unintended consequences of administrative burden on this.
We'll take that back. I do want to say that, it is our feeling that, in all these instances, we don't compel a school to go and provide education in other states. That's an institutional decision. So it's always up to the institution whether or not they want to do that. When an institution takes the step to provide, via distance education to students in other states, then it becomes, is it a burden to make these determinations and to make certain that that the licensure requirements are met, where you're advertising the program as providing an education to meet those licensure certification requirements? Yes, we concede that is a burden, but it is one institutions take on voluntarily, and with the expanded student base that comes with offering these programs this way, comes the responsibility to students. I think that it comes down to why are students taking a program that's educating those students for certification or licensure, presumably to get that certification or licensure and obtain employment. And understanding that it's possible that somebody who lives in Georgia seeks to relocate to Virginia. Obviously, nobody would ever leave Pennsylvania, but I'll leave that out. But I do think that when schools decide to do that, it is the department's position that's incumbent upon those institutions to make certain that those requirements are met. But I will take back the concerns.
Thanks, Greg. Carney.
Yeah, I just want to reiterate that I support any kind of measures of transparency for students. So I do appreciate this requirement.
Great, thank you, Carney. All right, Greg, you think it's time for the temperature check on? Was it 668.435?
A5, I'm sorry.
A5.
The A before.
The A. It wasn't an I or a J, but it was.
It wasn't I or J, but I blew it anyway. So yes, it's it's A5.
All right. If everyone could hold their thumbs up, please. All right, we have one thumb down. Okay. So let's see, that should complete certification procedures. Turn back to you, Greg. Do you want to start with the next topic?
Yeah, we're going to start with change of ownership and control. But before we do that, I need to take a brief break. So could we have 5 minutes?
Understood. It is 2:56 Eastern time, so we'll take a 5-minute break and come right back at 3:01.
Thank you very much.
Thank you. All right, welcome back from that short break. We just got through certification procedures. I'm going to turn it over to you, Greg, and we can start the next topic.
And then our next topic is changes of ownership and change in control. So we'll be pulling up the regulations there. And the first place that we're going to go to where we have any changes here is in 600 under definition 600 points. Let's make sure I get this right. 600.2. 3, 4, 5. And to go down there. So this is under, I'm sorry, this is under, and I should say this is under, oh no, this is, let me get this right. Under distance education, this is number 6. So we're starting into distance education 1, 2, 3, 4, 5, 6. The problem with this is in definitions, things are numbered a little bit differently than they are in other sections, so it can be a little confusing. So we're starting in 6, and we have added language here to conform to the forthcoming amendments to regulations to address prison education programs. So you can see that reflected in 6, except for an additional location at a correctional institution as described in the definition of an additional location in this section. For an institution that offers on-campus programs and distance education programs, the distance education programs are associated with the main campus of the institution. For an institution that only offers distance education programs, the institution is located where its administrative offices are located and approved by the accrediting agency. So just want to point that out, and that is to account for changes made in prison education, and we did achieve consensus there, so that regulation will stand as it is. And then we move down to the definition of a nonprofit institution under 1 Romanet 4. And this is in response to negotiators' comments. The department has proposed to add language clarifying that this language is non-exhaustive. So in Romanet 4, when the secretary makes the determination regarding net earnings, the secretary considers the entirety of the relationship between the institution, nonprofit entities, and its ownership structure and other parties. And in 4, and then going down to trying to see if, okay, no, I think that's it for not-for-profit institutions. And for we move down to that is it for the definitions then in 600.2. So we'll stop there and open the floor for discussion.
Thank you, Greg. Before I get to you, Yael, I just want to mention that Donna Mangold is in for the Office of General Counsel. Welcome. And let's see, Yael, you're up first.
Thanks, and I apologize if I'm a little turned around right now, but I think there was proposed language here with respect to the definition of nonprofit that would have expressly included arrangements such as leases, it's longer-term leases between previous owners and entities with the new nonprofit as an arrangement that would not qualify as nonprofit. And I really want to emphasize this. It's inclusion language that was included and that we supported in part because we have actually seen this in practice, that one of the points where the previous for-profit entities or the owners of the for-profit entities maintain close financial relationships with a new entity that should be of great concern to the department and are of great concern to us are included in these like long-term leases of all of the brick and mortar, campuses and equipment of the previous institution. And these are problematic arrangements. So I was hoping that you might be able to provide some insight as to why that suggestion wasn't included. Greg, you're on mute.
We still have that in consideration. Some of them we have not been able to put in yet, and so we will address that. Donna, do you want to speak to that at all?
No, just to tell you that leases are something that we are looking at anyway, but we'll take the issue of having it in the regulations more specifically back and look at, but it is something we look at now for sure.
Thank you, I appreciate it.
Brad, you're up.
I'm back up in 6 here, the first part, and it's not about the correctional institution. I just remember there was a lot of back and forth about why we want the distant ed program associated with the main campus to be approved in the same state. I know this could be an administrative burden to comply with this proposal and move our distance ed programs to the main campus. We'd have to seek additional approvals from states and creditors. I just don't recall getting to consensus on 6, so maybe I'm forgetting, but I remember there's a whole lot of back and forth of that'd be a heavy lift if we're going to really do that. And Jamie's shaking her head. So yeah, so did we resolve that issue? Mention that.
Where are you in 6, Fred?
I'm in 6, not what you added in 6. It's the statement that says for an institution that offers on-campus programs and distance education programs, the distance education programs are associated with the main campus, and it must be located where the administrative officer are located and approved by its accrediting agency.
Right, for an institution that I see what you're saying. For an institution that offers only distance education programs, the institution is located where its administrative offices are located and approved. Right.
Right, that's just not the way it works in operation today, and we didn't really resolve that. So I just want to call.
I'll open it up if you want to. I certainly will entertain comments about that.
I mean, we hit on this for a long time in week 1, and I just don't think we got to a resolution. So. Maybe I'll defer to Jamie next because I know he and others had some things on this one.
Bormack, you're next. If Jamie, you want to join the queue?
Yes, I'm on the same provision and have the same concern. It's worrisome to suggest that an institution's location, that an online institution's location could be a storefront in the least demanding jurisdiction it can find, when it is actually delivering education to significant numbers of residents of another state. It seems to me that this issue of location has to be tied to where the education is being delivered, and if it is in more than one state, maybe we can peg it to where they had the largest number of students for the previous X many years. But tying it to headquarters just doesn't make a lot of sense to me because headquarters can move. We have not regulated higher ed institutions that way. In general, higher ed institutions don't tend to move physically when they're brick and mortar. It is very easy to just move an office from one state to another state across the country. So this creates forum shopping and a real race to the bottom. Leaving students unprotected in the state where the institution may be delivering the most education.
And Barbara, do you have suggested language for how you would?
I submitted. I'm not wedded to the language I submitted. I defer to the wisdom of the group. But I suggested as a policy proposition, if you had to pick a state for an institution that does not have a physical presence anywhere, that state would be where it enrolled the largest number of institutions during the previous X many years. I don't care how many years, but to make it workable, to just suggest that they should be under the jurisdiction of whatever state they did the most business in.
Okay, thank you. Any other comments on that?
Thank you, Barmack. We have Brad up.
I'll go behind Johnson because I've got another section, so.
Johnson?
Thanks. Yeah, I would just echo Barmack's statement. You saw this with credit card companies. They all went to either North or South Dakota. I can't remember which it was that didn't have a cap on interest rates. So it's, you know, if there is no physical place, they're gonna find a very sympathetic, profitable place to move to, and it won't serve the students well.
Brad?
You know, I'd like to confirm something. You know, a few days after the first session on January 27th, I asked the department for a clarification about the nonprofit definition. And what I'm looking for here is a public institution is a type of nonprofit institution under the Higher Education Act. And so what I'm exactly asking is, do we consider publics institutions a form of nonprofit, and will they comply with number 4? I guess that is under Main Campus 1, Section 4, into that nonprofit institution is generally not an institution that. Does nonprofit include publics in that definition there in 4, last sentence? And I'll add down to 600.4 right below it. It does say that, but I just want to confirm that with the department.
So you're talking about 1 Romanet 4?
Yeah, last sentence.
For purposes of participating in the federal student aid programs?
Yes.
Okay, a nonprofit institution is not an institution that has an obligor either directly or through any entity that's ownership on debt owed to a former owner or institution. Or for either directly through or either directly or through any entity in its ownership chain enters into or maintains a revenue-based agreement with a former owner of the institution or a natural person related to or affiliated with the former owner. So you're talking here about an instance here, Brad, where a public institution may have those things. I'll ask Donna to respond to that.
And I asked if we could send that question to Donna back on January 27th, so hopefully she had a chance to look at that.
I'll give her a chance to respond.
Chance to get off mute. The definition under the HEA does say other nonprofit, which we believe means that a public has to be treated in the same way as a nonprofit.
Okay, well, that's answered my first question. So then in Romanet B, when we talked about revenue-based agreements, I assume then Purdue, University of Arizona, University of UMass, University of Arkansas are now subject to gainful employment? Am I reading that correctly? Because they have revenue-based servicing agreements.
Take a look. This has to do with how we evaluate whether a school can convert. And these are the categories that we deem to be examples, and we'll be looking at all of them in terms of new conversions.
So new conversions only going forward?
Well, we'll take back the issue in terms of looking backwards.
I'll get back in line.
Barmack.
Wasn't somebody else ahead of me? Okay, I'll go. I'm interested in the same provision, and I'm concerned that not all, I don't know that publics are necessarily 501c3s. So it seems to me like you really need to take a look to ensure that these provisions apply not only to entities that convert to 501c3 status, but also entities that purport to be public institutions. Whether you apply it retroactively or not, it seems to me, I just want to emphasize that we had conversations elsewhere with regard to financial responsibility specifically, where the definition of public needs to be firmed up. It would be non-controversial now. It won't be non-controversial for very long because publics are headed in an ominous direction here. So I hope you can make those conforming changes there as well. Thanks.
Thanks, Barmack. Brad, you're up.
So I just want to go back to the question, and I do think there is statutory guidance, and Donna referenced it, Barmack. So I do think you don't have to be a 501c3 to be considered a nonprofit. You actually just read 600.4a right below it. It says an institution of higher education is a public or other nonprofit education institution. So to me, that's your answer right there. They are nonprofits. So back to my question here. If you're not a nonprofit based on a revenue-based agreement, then by definition, I guess you qualify for GE as a for-profit. And it doesn't say a retroactive date. I'd like to continue the discussion. We know these are in place. I just referenced 4 of them that are active in place right now. Are they subject to GE if this rule passes as is?
We need to take a look at that issue, specifically with regard to the GE question you're raising.
Well, I think they should be. Thank you.
Brad? Jamie, you're up. You're on mute, Jamie.
Barmack's point about the location question and where education is delivered. I don't want to do dueling hypotheticals, but if an institution is based in New York and provides distance education and its students gradually over time shift south and west, your approach would require that New York State institution to move someplace. Its students are less fixed than an institution, and the students move too. So a simple approach like where your students were for the last 5 years, the largest number of students for the last 5 years, could change, and you'd be asking an institution to move every year. And while I can solve that by saying one of the top 5 or one of the top 10 where your students are located, I think the point is we need better ways to get at the quality of the institution and the variety across states, and recognize that there are both federal and accreditation reviews in addition to the state level. Even if you're frustrated, which I understand some people are, with all 3 of them, the solution is so potentially distracting, confusing, unhelpful to quality control and accountability of an institution to move around in that way, that I think we should focus on better ways to accomplish that. Then I have a footnote, just some of the things that Brad is saying, and while I respect the importance of answering those questions, some of the assumptions you're making about the nature of agreements are, to my knowledge, not accurate. So I just want to be careful that people don't assume that he is accurately describing the nature either of the status or of the arrangements that at least some of the institutions are involved in. Donna does, but not everyone knows all of them.
Thank you, Jamie. We have Barmack and then Brad. Just want to give everybody a quick time check. It is 3:22. We do have 3:23. We have public comment coming up in 7 minutes. So Barmack and Brad, you guys are up.
Yeah, I appreciate Jamie's comments and I agree with her that we do need some sort of a more nuanced approach. It's just that I don't think a storefront should qualify. You're essentially allowing the institution to select who its authorizer is going to be and to which states consumer protection particularly under current reciprocity agreements. You're basically allowing the institution to select whose consumer protection laws it's going to apply nationally. So I see that as a problem. I concede that focusing on the students retroactively may not be the best solution, but that's the best I could come up with. I would welcome some more dialogue on the topic at some point.
Thank you, Barmack and Brad.
You know, I don't know all the specifics of the West Coast deal that maybe Jamie does, but I do know, you know, Purdue acquired capital for $1 and entered into a 20-year revenue share agreement, and UMass paid a sizable amount of money for Brandon. And I need to look into more on the Arkansas Grantham deal, but I just want to point out that we need to apply these rules consistently to all programs. I mean, in all areas of higher education, and we can't just separate out ones because we like them or they're big names or they're have big basketball teams. So I want to be clear on this. By the way it reads, we need a clear definition of whether or not Purdue is considered a for-profit from this point forward. Thank you.
Thanks, Brad. Let's see. I don't see any other comments. Greg, would you like to take a temperature check on, was it 600.2, the definitions?
Sure.
Okay. We have everyone's thumbs up high on 600.2, the definitions. Okay, I don't see any thumbs down. Thank you. I'll turn it back to you, Greg. Just be mindful, it's 3:25.
Right. Just looking at 600.4 briefly, I think we can probably get this list, go through this, even if we don't finish discussion on it. So if we can have Renee pull up 600.4. There we are. Institutions of higher education, and we have made a change here in A. We have deleted the word private to match the statute exactly, and led us some confusion about the text from some negotiators. So an institution of higher education is a public or other nonprofit educational institution. And that is the only change over the last mandatory text that is in 600.4. So we do have a brief amount of time if we have any comments about what is there.
Okay. Are we
I
at
have only
the
one comment. We would have done a better job writing that sentence than Congress did.
Well, we just won't tell them that, right?
And we have Emmanuel joining us for a comment. Go ahead.
Hello. Yeah, I believe this was pretty much clarified in the previous discussion, but I just wanted to make sure because we were hearing some concerns about the way this was drafted, and I understand now that you're just taking the exact language that's in the HEA. But is it your intent to treat all publics as if they are 501c3s? Because technically not every single public institution is a 501c3.
I don't believe so, but I'll let Don address that.
I'm sorry, can you give the question again?
So what I've been hearing back from folks is they were a little bit confused as to why in 600.4 you added the word other. And now I understand that you did that because in the HEA, it says it's a public or other nonprofit institution. Right. But is the intent of the department to treat all public institutions as nonprofit institutions? Since every single public is not technically a 501c3. The vast majority of them are, but not every single one.
And we have to maybe take a look at the language again to see whether it makes sense to actually, for purposes of Publix, to include that as the same kind, as the requirement as it is for other nonprofits. So that might solve that issue. But we need to take a look at that.
Okay, yeah, further clarification would be great.
Thanks, Donna. I think we probably have to cut it off soon, I'm saying, so we probably ought to forgo any more comments until tomorrow.
I was just going to say the same thing, Greg, which was it's probably a good stopping point. We can carry over tomorrow with 600.4, and we should be ready for public comment momentarily. It's 3:28 Eastern.
All right, Kevin, shall I begin admitting folks?
Yes, please. Who do we have, Brady?
All right, our first speaker is Jessica King, representing themselves. They are a veteran.
Thank you. Good afternoon, Jessica. Can you hear me? Jessica, can you hear me?
She's logged in under Jen. So Jen, can you hear us? Oh, you just muted yourself, but sorry, take it away, Kevin.
No, go ahead. Jen, can you hear us? Or Jessica?
My name's Jenica. That's
Oh, Jenica. Okay, welcome.
Hi, everyone. So sorry.
That's
I'm pulling
okay.
up my my little statement here. They said to stick with it. So
All right.
can everyone hear me properly?
Yes, we can hear you.
Okay.
Thank you. You have 3 minutes for public comment, which will begin when you start speaking. Go ahead.
All right. Good afternoon. My name is Jenica King, and I'm an Army veteran and the spouse of an active duty service member. I used my GI Bill to attend Ashford University. One reason I went there is that they stressed that they were military friendly and that my GI Bill would cover all my tuition. I trusted them, so in December 2016, I enrolled in the bachelor's degree program for psychology. Pretty soon, I found out that military friendly was just empty words to get me to sign up. There was nothing special that veterans received, and actually, I felt mistreated. The school made me feel irrational when I asked about my financial aid and other administrative questions. They were short and rude with me, and the counselors and military representatives that were promised were nowhere to be found.
Jenica, it looks like you got muted if you want to unmute yourself.
Okay, trying to see where was the last part you guys heard.
It was only for about 10 seconds. You just want to walk back.
Okay.
You are nowhere to be found.
Okay, mistreated. Okay. So the school made me feel irrational when I asked about my financial aid and other administrative questions. They were short and rude with me, and the counselors and military representatives that were promised were nowhere to be found. Even the instructors were not responsive to the mental and physical injuries commonly faced by veterans. But the biggest problem came in April 2020 when I was a few months away from graduating. I learned that my GI Bill benefits had expired in March, but the school did not tell me so I could take steps to find other benefits or ways to cover my tuition. Instead, Ashford just put a balance on my account and expected me to pay out of pocket. I was shocked that the benefits were gone when I was promised they would cover everything. And I was furious that they were not lifting a finger to help me find a way to finish my degree. Then when I reviewed my balance, I realized the problem was worse than I thought. I found that the school was not applying the full military discount that the recruiters had promised and I had received earlier in my time at the school. Also, I discovered I was being overcharged for courses and being charged a higher rate than I was told when I enrolled. This meant that my GI Bill benefits were exhausted long before they should have been, and I owed a debt that never should have been there. When I finished the program, Ashford told me that they would not give me my transcript and degree if I didn't pay the balance they claimed I owed. This was a major problem because I was hoping to continue my education at a different school or get a job, and I really needed my transcripts and degree to do that. The bottom line is that Ashford made promises to get me to enroll at the school that did not turn out to be true. I would never have gone to Ashford if I had known that my GI Bill was not going to cover all my tuition, and that Ashford is unfriendly and unhelpful to military veterans, especially those experiencing issues like PTSD. I hope that you write strong
30 seconds,
policies.
Jenica.
I hope that you write strong policies to protect veterans and stop the type of recruiting and financial aid problems that I experienced at Ashford. Thank you.
Thank you, Jenica, for your comments and for your service.
Thank you. No problem. Bye.
Who do we have next, Brady?
All right, Kevin, I just admitted Artie A.S., who is representing themselves.
Okay, great.
Hi, this is Artie. Can y'all hear me?
Yes, Artie, there you go. If you could, if you're comfortable, enable your screen, that'd be great. If not, you have 3 minutes for public comment, which will begin when you start speaking.
Okay, and I'm with AYA, I wanted to say.
Okay, thank you. Go
Okay,
ahead.
so I'll go ahead and start. Thank you for this opportunity to speak and to share a sliver of my student loan experience for the purpose of advocating for gainful employment and financial responsibility. As a child of working class immigrants whom I saw in multiple uniforms a day as they switched shifts between places of employment, my student loan experience has been a dark cloud of shame and guilt hovering over the past 12 years of my adult life. Higher education was supposed to be the great equalizer, the mechanism to break the cycle of overworked and underpaid people of color. It was supposed to be the tool that empowered generations like mine, the most diverse at its height, to give back to the country they love, build a foundation solidified by opportunity, and make up for the burdens of our parents who sacrificed in the face of inequities to give us the American dream. The higher ed dream was taught to me throughout my formative years. I now understand that this dream was illusory. The path I was encouraged to take was not cultivating a manifestation of this dream. Rather, it was targeting me to fall prey to the harsh and impressive impact of student loans for others to profit. To illustrate a real-life example that I wish were only in theory, I graduated from college in 2006 from a well-known public university. There were no job prospects for me when I graduated, and then I also went to law school. The job outcome after law school was the same. At the time, neither entities offered much viable, relevant help in the job realm. The way you made it was by who you knew or through cushion of generational wealth. The rest of us were left to our own devices struggling. I ended up taking a position at a nonprofit with a starting salary of $32,000. The curious part is that it took me 2 degrees to get to a position that someone else could get with a bachelor's degree due to the connections they had or the familiarity they had with the sector's landscape by virtue of who they were in the society, likely a non-person of color. What I mean to say is that me as a South Asian, I did not have awareness or access to a variety of career paths because I didn't know anyone in diverse industries. So it took a lot more resources, including time and settling for salaries to even make it into a field which I was overqualified. $100,000 plus in debt plus interest and a $32,000 income is not viable. It is not possible to build a future with this. Furthermore, this is not the deal I made when I signed up for loans. In fact, I was reading an artifact received in high school from the 2000s that discussed if education was worth it. It postulated that higher education was more valuable than not having a degree and showed a scale of on average, how someone makes with a degree. With a postgrad degree, it was supposed to be 96 to 144K. With a high school degree, it was 46K. I graduated law school and started at a salary of $32,000. That is below both the postgrad and undergrad degree averages. I believe that if there were accountability practices like gainful employment available, this would not have happened. This also goes to show that opportunities are not the same for everyone, especially working class families and those who are Black, Indigenous, or people of color. As such, because non-white borrowers and working class families are more likely
30 seconds.
And experience more inequities in access to jobs as well as salary in their careers, the U.S. Department of Education needs to insert accountability measures to ensure that these groups are not oppressed by predatory loan tactics and promises of a dream which society has not yet made a reality. Reinstating gainful employment will help ensure that these student borrowers are no longer just targeted, groomed, and exploited for gain. Then I had more, but it's going to be too long. Thank you all so much for the time.
Thank you for your comment.
Thank you. And can I submit these comments via email as well?
Sure.
Okay, thank you all so much. I really appreciate this.
Thank you. All right, Brady.
Hey, I just admitted David Rhodes, who is here representing the School of Visual Arts.
All right. David connecting. Hello, David. Can you hear us?
I can hear you.
Great. Welcome. You have 3 minutes. Yeah, you have 3 minutes for public comment, which will begin when you start speaking. So you have the floor. Go ahead.
Thank you. Good afternoon. My name is David Rhodes. I'm president of the School of Visual Arts, SVA, in New York City. Thank you for the opportunity to comment on the gainful employment regulations. In Anthony P. Carnevale's most recent paper on ROI for low-income students based upon long-term earnings, SVA ranked 998 out of 3,110 institutions. Even though SVA ranks in the top third of institutions, since the 2014 GE metrics were applied only to for-profit programs and short-term programs and used only short-term earnings, some of SVA's programs failed. If the same metrics were applied to degree programs at public and not-for-profit institutions, it's almost a mathematical certainty that some would score lower than SVA's programs and fail the metric. Therefore, it is difficult to see how this advances the department's goal of ensuring that low-income students have access to programs that can benefit them over their working lives. Recently, the Secretary updated the college scorecard median earnings data. SVA's graduates' earnings increased from $29,900 for 6 years after graduation to $50,066 10 years after graduation, exceeding the median for all four-year colleges. Given the volatility of results depending upon the date chosen to measure earnings, it is difficult to justify that earnings shortly after graduation are a reliable way to judge the quality of a program whose benefits accrue over a lifetime. Ultimately, the 2014 GE rule as constructed is complicated and out of date. At a minimum, the department's current proposal has not cast the net wide enough to protect students from programs at all institutions that would fail the metric. If the department truly wants to put students first and center students in this discussion, it would use its existing authorities to develop a programmatic debt earnings metric widely available to prospective students for all programs that did not arbitrarily impact
30 seconds, David.
And not others. Thank you.
Thank you.
Thanks for the warning.
Thanks for your comments.
You're welcome. I now disconnect. Is that it?
Yep.
Thank you very much.
All right, Brady, here we go.
I just admitted Warren Rosenberg, who is here representing the College of Westchester.
Great. Welcome, Warren.
Thank you. Good afternoon.
You have just want to let you know you have 3 minutes for public comment, and it'll begin once you start speaking. So take it away.
Wonderful. Thank you. The regulations being considered by the Education Department are directed toward continuing to unfairly and unjustifiably punish colleges in the proprietary sector for outcomes that are, in fact, often better than those of many institutions in the public and not-for-profit sectors. For institutions like the College of Westchester, which are members of New York's Association of Proprietary Colleges, or APC, outcomes as cited by third-party sources are among the best in New York State and the nation. For example, the 2022 U.S. News ranking lists the College of Westchester as one of the top 20 regional colleges in the North, with 2 other APC colleges rated within the top 40. Within the U.S. News New Social Mobility category, the College of Westchester has been ranked as the #1 regional college in the North among all sectors, with another APC college making the top 20. In a Georgetown University research study released just last month, highlighting colleges where low-income students get the highest return on investment, the College of Westchester, again as an example, was ranked #1 in the nation among private for-profit colleges that grant associate degrees and serve more than the national median share of Pell students. And we are not alone. The government's own data, released by the National Center for Education Statistics, shows that through the 2 decades between 2000 and 2020, the cost of undergraduate education, and that's exclusively tuition and fees, has increased by 167% at public four-year institutions, by 126% at private not-for-profit four-year institutions, while increasing by only 44% at proprietary sector four-year colleges. America's proprietary sector colleges have been more successful at controlling their tuition costs than have their counterparts, private not-for-profit sectors, yet continue to be unfairly characterized as predatory. Granted, there are some poor performing colleges in all sectors, but holding all colleges in the proprietary sector accountable for the poor outcomes of some, while ignoring the poor outcomes and escalating costs of many public and private not-for-profit colleges is unfair and unjustifiably penalizes
30 seconds,
low-income, career-focused students served by this sector. We applaud and support the appeal of 17 Democratic members of Congress in their November 18, 2021 letter to the House leadership to, and I quote, bring accountability to all sectors of higher education and not to single out and publish proprietary sectors at the risk of having, and again I quote from those congresspersons, the disparate impact on minority and
Warren,
first
your time's
generation
up.
students. Thank you.
Thank you.
Thank you, Warren. Brady, before you let someone in real quick, I just wanted to mention that there's no submission of written comments at this time, and they will be opened up during the NERM period of this process. That being said, Brady, who do we have?
I believe they are all set. We have Jared Bass, who's here representing the Center for American Progress.
That's great. Jared, welcome.
Hi, thank you.
You can hear us, obviously, right?
Yes.
Okay, great. You have 3 minutes for public comment, which will begin when you start speaking. Take it away.
Great, thank you. My name is Jared Bass, and I'm the Senior Director of Higher Education at the Center for American Progress, and thank you for this opportunity to comment. At a press conference on January 27th, Secretary Cardona said, because we need to make sure schools that focus on career programs aren't leaving students with mountains of debt and without good job opportunities, we've begun the process to create a strong gainful employment rule. Students will not be taken advantage of for financial gain, and all we do at the department will be student-centered. A strong gainful employment rule must be student-centered. As you shape the gainful employment rule through this negotiated rulemaking, keep the following students in mind. The students have granted permission for their names and stories to be shared. Ariel from New Hampshire is a Latina borrower from a low-income background who graduated from Full Sail University in 2020 and knows around $100,000. Ariel says she pursued higher education to be an animator, and the requirement for the industry is to have a bachelor's degree. Ariel is discouraged. She's been unable to find employment in her field, and she's afraid of her financial outlook for when she has to start making payments. She says, in total, I'll be paying around $800 a month just for my student loans. I'll be making minimum wage, which is $15 an hour. Considering taxes and all, I'll only be bringing home $2,000 a month. My loans are half my overall income. Ariel reported currently being unable to afford food, medical insurance, and other basic necessities. She says, I'm struggling to find hope that I won't be homeless someday. Michael from Illinois graduated in 2014 from DeVry University and is a first-generation Asian American borrower and a parent who owes $300,000. He defaulted on his loans. Michael says that he pursued his degree to get a better paying position and learn how to make change for the businesses I work for. But even years after graduation, his career prospects have not improved. He says, my wife and I are just barely able to meet our obligations, and the student loan debt has been like an anchor. The school's recruiter claimed I should be able to be more marketable with a master's degree, but I still can't seem to make what I deserve. Michael just wants to be able to provide for his family, but fell prey to questionable practices of a for-profit college. These student experiences underscore the urgent need for improved accountability measures to prevent for-profit institutions from continuing to mislead students. Regulations and regulatory choices have implications not just for institutions, but for students and borrowers as well.
30 seconds.
Thank you. These are real lives that have been damaged. Ed can hold for-profit institutions accountable for the experiences of students like Ariel and Michael by drafting and enforcing a strong gainful employment rule. Thank you for your time.
Thank you, Jared, for your comment. Ready to reiterate?
Kevin, I just admitted Susan Haste, who is the owner of the Institute of Beauty and Wellness.
Welcome, Susan. Can you hear us?
I can hear you perfectly. Thank you. I just had to unmute. My name is Susan.
Real quick before you get started, I hate to interrupt. You have 3 minutes for your public comment, which will begin right when you start speaking. Take it away.
Thank you very much. My name is Susan Heisey. I'm the owner of the Aveda Institute of Beauty and Wellness located in Milwaukee and Madison, Wisconsin. I've been teaching in the industry in school management for the last 28 years. 94% of my students are women. 52% of them are Pell Grant eligible, and more than half of my graduates desire to own their own small business after they graduate. Since 1993, when I opened the school, I've graduated thousands of students who have gone to work in successful salons and spas and have opened their own small businesses. I want to emphasize my commitment to education that not only leads to licensure, but also leads to a fulfilling career in the industry. 79% of the graduation rate is 79% for our institutes. Our median loan debt is approximately $6,333. Our graduates' monthly payments are $63. And my median earning in the first 2 years of employment is, after graduation, is $34,885. I care deeply about my students and their future. I'm here today to highlight my primary concern, which is the proposed gainful employment rule. I am a supporter of documentation in being gainfully employed for all educational opportunities, both for-profit and not-for-profit. It is well recognized that the cosmetology industry has a high prevalence of underreported and unreported income. The 2014 rule provided institutions with an appeal option. Does not include the opportunity to appeal. And I do think that that is essential for all properly run businesses to be able to appeal. Currently, or instead of acknowledging, we currently—
30 seconds, Susan.
Thank you. We currently provide, when were providing, they were audited. 50% of our students needed to provide us with income information that was audited and unbiased. A valid appeal process should be provided. I want to close by reminding you that our schools are, my schools are dedicated to our students. They have high student outcome rates. We're supporting small businesses as well as lots of women in our community who need flexibility in their lives.
Susan, your time is up.
Thank you so much for the opportunity today.
Thank you for your comment, Susan. Right here we have.
All right, I just admitted Will Hubbard, who's here representing Veterans Education Success.
Welcome, Will. You have 3 minutes for your public comment, which will begin when you start speaking.
Great. Hello, and thank you for the time to present here today. My name is Will Hubbard, and I'm a proud Marine Corps veteran, and I serve as Vice President for Veterans and Military Policy with a group called Veterans Education Success, and indeed, that is our mission. As you work on gainful employment, financial responsibility, administrative capability, and the rest of these important topics, I feel it's imperative that we remember why exactly we're all here. Who, after all, is the ultimate customer of higher education? I've received permission from several student veterans to share their voices here today as a reminder of the very real consequences of these negotiations. For them, these are not just policy discussions, but rules that have life-changing impacts. First, Chris, a Navy veteran from North Vernon, Indiana, says, "While I was recovering from spinal surgery, I decided to put my hard-earned GI Bill to work and get a college education. I chose ITT Technical Institute. I chose wrong. I did finish school, but I did so with issues still from ITT and still don't have my degree. ITT refused to release my transcripts. I still haven't received a reason why. Further, ITT soaked up all of my GI Bill money and then took out student loans for me without my knowledge." Second, Patricia, a Navy veteran from Coconut Creek, Florida, reports, "As the first person in my family to attend college, I didn't understand the enrollment process. And I believe DeVry willingly took advantage of that. Low-quality, for-profit schools like DeVry have robbed many of us of our hard-earned GI Bill benefits, leaving us with worthless degrees, crushing loan debt, and zero job prospects upon graduation. Third, Jay, a Marine Corps veteran from Oregon City, Oregon, had this to say. 1 year before I left the service, the for-profit university, University of Phoenix, began contacting me non-stop, trying to convince me to enroll. They called day in and day out, declaring themselves a military-friendly school. I enrolled in their online Bachelor of Science in Business. Soon, however, I learned the hard way that Phoenix's hard sell was just that, a sales pitch. And fourth, Carlette, a Navy and Air Force veteran from Austin, Texas, notes, the University of Phoenix lied when it was recruiting me and strung me along
30 seconds, Will.
all of my money from my military benefits that it could. They actually came onto my military installation and lied to me and my fellow vets. They kept adding courses that were not pertaining to my degree plan. They changed my program twice without my knowledge. As we close tomorrow with the discussion of the 90-10 rule, please let's remember who this is about, the students. Thank you.
Thank you, Will. Your comments? We have Ray.
I just admitted Tomas Leon, who is here representing themselves.
Welcome, Tomas. Can you hear us?
Yes, I can. Can you hear me?
Yeah, great. Before we get started, you have 3 minutes for public comment, which will begin when you start speaking. Take it away.
Great. Thank you so much. Well, thank you for having me. Hello, my name is Manuel Tomas Leon. I'm a father of 4, married for 31 years. I grew up from humble beginnings in Abadio, a neighborhood on the west side of Tucson, Arizona. I started a family early in life and began pursuing my education as a student athlete. After overcoming many barriers to completing my bachelor's degree as a first-generation student, I wanted to earn my master's degree. I looked around for MBA programs and could not find one that reflected my life circumstances and how busy I was as a father, as a husband, and in my career at that time. I was fortunate that to be introduced to the University of Phoenix, which offered me flexibility to take classes, test, and participate in learning groups on my time and on my terms. The conventional university doesn't work for everyone. Students need an innovative university that meets them where they are at in life and in their career, that provides an exemplary academic curriculum and experience. I'm a proud alumnus of the University of Phoenix and grateful that it allowed me to achieve my life and career goals. It enabled me to have a very successful career as a healthcare executive, an entrepreneur, investor. I am living the American dream. I'm not a veteran, but my father proudly served in World War II, and I have a brother-in-law that's a veteran. In honor of their service and others, I believe that the proposed rules 90-10 under 34 CFR 668 2.8 will have a particular impact on veterans and how they use their GI Bill and other federal funds to pursue higher education. This will have an unfair and unjust impact on veterans. I believe this rule will take the decisions out of the hands of veterans as to how they define quality education and the institutions they select to pursue their education. At this point in our country's history, we need to promote policies and rules that advance diversity, equity, and inclusion, not exclusion. I want to thank you for considering my thoughts and my feedback in supporting veterans' choice to fulfill their American dream. Thank you for your time.
Thank you, Tomas, for your comment. We have next, Brady.
All right, I just admitted Roxanne Garza, who is here representing Unidos US.
Welcome, Roxanne.
Thank you.
Before we get started really quickly, you have 3 minutes for public comment, which will begin as soon as you start speaking. Take it away.
Good afternoon. Thank you for providing the public with an opportunity to comment on the topics presented to this committee. My name is Roxanne Garza, and I am representing Unidos US. And as a leading advocate on education policy encompassing the perspectives of Latinos in higher education, we strongly suggest that the committee take into account the unique experiences of Latino students and borrowers as you come to the decision on these regulations. The gainful employment rule in particular has serious implications for Latino students who tend to be the first in their family to go to college. And it's also common for them to be older, have children, come from low-income backgrounds, and enroll part-time. This makes them especially vulnerable to the promises made by predatory colleges to provide flexible schedules and gainful employment after graduation or program completion. In my comments today, I will share a story of a student who granted permission for his name to be shared. Luis Soto Torres graduated from Kaplan University online and says he was lied to about his degree and his loans. He graduated in 2010 and now owes $92,000. Luis is struggling to afford his loan payments. He originally pursued higher education because, quote, I wanted to be the first in my family to go to college. Without student debt, he planned to continue his education and fulfill his dream of starting a business to serve his community. Luis says, quote, some of the colleges and universities are using students to make money out of them. When I went to college, loans were thrown at me like it was my only option to get an education. Luis was preyed upon by Kaplan University online, like thousands of other Latino students, and was sold a low-quality education targeted by lenders, and now he finds that his degree did not get him any closer to fulfilling his dream. Luis is not an exception. Without a strong GE rule in place, Latino college completion, debt accumulation, and earnings outcomes will only worsen. Latino students already experience lower completion rates due to a myriad of systemic barriers in higher education. But when they attend for-profit colleges, they often end up with lower completion rates, higher debt burdens, and default rates. These outcomes should alarm anyone who's promoting racial equity in higher education. For-profits often promise students well-paying jobs right after graduation, but more than half of these institutions leave many of their graduates earning less than a high school graduate. And we often hear an argument from for-profit institutions that the demographics of their students are what's at play in their failing of the GE rule. That it's the racial wage discrimination that the students face in the labor market that makes it more difficult for their graduates to repay their loans. Yet
30 seconds, Roxanne.
Yeah, while this is true that racial income disparities exist in the labor market, we've also seen recent data that show that Hispanic serving institutions are actually shown to provide the most economic mobility for their students. And other research points to the fact that there's little correlation between the share of Black and Hispanic students and failing a high school earnings metric, and that it has much more to do with the sector level and size of the institution. The department can restore the promise embedded in the Higher Education Act, a key civil rights law built upon the idea that additional education was essential
Your time is
to all
up,
Americans
Roxanne.
for social and economic mobility. Thank you.
Thank you, Roxanne. That completes the public comment for today, for Thursday. This is the end of the session for today, and we will pick back up tomorrow at 10 o'clock. I want to thank everyone for their time and their comments and all your hard work, and see you guys tomorrow. We can stop the live feed.